Looks like council is ready. Our next case for the afternoon is the estate of Anderson versus State of Iowa. Mr. Mahoney, you may begin.
May it please the court, counsel. This is a case about form over substance. It's a case about Carter Anderson, who was a son of Alexandria and Terry Anderson. Carter was a boy with severe disabilities and required a feeding tube in order to eat. When the feeding tube became dislodged, he sought care at the University of Iowa hospitals and clinics. And our allegations were that the attending physician misplaced the feeding tube so that when he ate, any food ingested went into the wrong cavity and essentially led to an infection, poisoning him, and led to his tragic death. And in this case, we filed a state tort claim on May 6, 2020, and received acknowledgement on May 15, 2020, and Alexandria Anderson was appointed as administrator on May 29, 2020. 6 months later, on November 24, 2020, we withdrew the claim, and 2 months later, filed suit. Then the suit was litigated for approximately 9 months before a motion to dismiss was filed, and the district court dismissed the claims based on two primary factors. The first is that the estate was the only party that filed a claim. The parents did not file an individual tort claim form for both Alexandria and Terry. And then the second was that Alexandria was not appointed at the time the claim forms were filed. It was 14 days after the forms were acknowledged as received and 21 days after the forms were sent. And we believe the district court erred for 4 reasons. First, we believe that they erred in finding that we didn't meet the requirements for presentment and exhaustion. Second, the court adopted and rewarded the state for not investigating this claim. And third, the court erred by finding loss consortium claims for parental consortium for loss of a child was the sole type of consortium claims that could not be joined to an estate under Rule 1.206. And fourth, that the appointment of Alexandria Anderson did not relate back. And this brings us to the first concept of presentment and exhaustion. It is our opinion that the claim was properly presented. And what we think the district court did is they elevated this idea of claims processing rules as discussed under Segura to be at the same level of the presentment and exhaustion requirement under 669.5. And Segura
Just sort of get to a couple of concerns. So as to Alexandria and Terry Anderson individually, they were not identified as individual claimants on any claim form, correct?
Anderson was identified as the mother in the actual claim form for the estate, and then a loss consortium claim was made in that.
Yeah, but she was not listed as a claimant.
The administrator being a claimant, yeah.
Right. She was not listed individually as a claimant. It specifically identified her in her official capacity, correct?
Yes.
And in fact, it was your position before the district court that Alexandria and Terry Anderson were not proper claimants.
I don't believe it was our position that they weren't proper claimants.
I'm reading from the resistance to the motion.
I understand. I'm sorry, Your Honor. And that's because the estate is the proper claimant, because the estate is the vehicle that these claims are brought through, that all wrongful death damages, including loss consortium claims, are brought through.
I'm just trying to say that as far as what you told the district court, because there's a lot of discussion in the briefing about whether or not Alexandria and Terry, they should be treated as individual claimants, and your position then was that they shouldn't be claimants at all, is my point.
The distinction here is that the estate is the proper claimant and the parents own the right of recovery as set forth under Madison v. Colby, and that these consortium claims have to be joined unless we show a compelling reason otherwise. So in our opinion, the estate is the claimant. They're the one, and I think the jury instructions for Iowa even state that damages be recovered by the personal representative. They go through and they list spousal and parental consortium as damages to be recovered by the personal representative. So if I wasn't clear in that, I apologize, but that's our position, Your Honor.
Well, Bloomquist to get the consortium claims reinstated?
Bloomquist dealt with a still living injured individual. So the difference there is there's no estate that the claim is to be brought through. So that joinder requirement set forth in Madison is not there. And there's also another key difference in Bloomquist, which is the idea that there was never any mention at all in Bloomquist of lost consortium on the actual tort claim forms themselves. The first time that lost consortium was ever mentioned in Bloomquist was in the actual litigation. So that lost consortium claim had never been presented to the State Tort Claims Board at all.
Was Terry's consortium claim referenced, or did you have to look to the medical records to see that possibility?
You had to look to the medical records, and be frank, Your Honor, that's not as strong of a claim of ours in this case, and I'll be honest with the court about that.
The claims sheets didn't actually identify whose consortium was lost.
What I'll say is the only people that can make a consortium claim are the parents for a loss of minor child. And Alexandria Anderson was listed as making a claim, and it said she was the mother as well. And in our mind, that's sufficient for this idea of presentment, where we're giving the key information necessary in order to investigate the claim.
You think that, I guess your position is that even though you don't identify people as claimants, Terry or Alexandria as individuals, that still gives sufficient information to investigate them as claimants?
That we didn't use that specific term claimant, but I think making the claim for lost consortium and identifying her as the administrator and mother, I think that's sufficient to give that key information where they can gather, well, she's the one making the lost consortium claim. And in this concept of presentment, I think that we presented the amount of damages and we presented the general facts and allegations or theories against the state. Now, I'm running out of time here, so I might just jump to a couple major points, is that I think the concept of presentment is somewhat like notice pleading in the state of Iowa. The idea is we essentially have to give the claim or give the state notice as set forth under Segura to trigger that investigation. And jumping to the subject of exhaustion, I think this is a real key point, is that administrative process has been exhausted under Iowa Code section 669.5 sub 1 if a claim is withdrawn after 6 months or the claim is denied. And when the district court looked through this case, they found that exhaustion might have been found in this case had the state actually denied the claim. And in our opinion, that is a district court elevating one level of exhaustion or one type of exhaustion above the other. And that actually rewards the state for not denying the claim, for waiting for us to withdraw it. And there's no distinction in the statute, in case law, or anything that says one method of exhaustion, either withdrawal or denial, is preferable over the other.
Ask another question about Alexandria as administrator. She was not the administrator when she made the claim, correct?
Your Honor.
And it seems to me that Voss pretty clearly says that you need to be the person who's able to make the claim to make a claim. And I'm curious about your response.
Glad you brought that up as time is kind of expiring here. But as far as Voss goes, it's distinguishable in a few ways. And the first and most important one is Voss, the administrator, wasn't actually appointed until 2 years after the claim was either withdrawn or denied. I can't remember which one it was. but it was 2 years after the administrative process ended. And Voss actually said, and in our position, anticipated, they said because there was no pending administrative claim in which the appointment could relate back to. So in our mind, that's completely different, as there was a pending administrative claim. And I think this also, if I can elaborate with, I think there's a big problem in the state and the district court's reasoning about the application of the Iowa Rules of Civil Procedure. Because Voss clearly deals with the concept of a real party in interest. And they say that every action must be prosecuted in the name of the real party in interest. And then the district court and the state take the position that, well, the term action means it can't apply to claims. And Voss clearly states the opposite. They say, well, clearly it must be brought in the name of the real party in interest. So in our mind, Rule 1.201 has to apply, because otherwise you have this multiplicity of suits, you have the possibility of double recovery, anyone can file a claim for anyone. And as far as Voss, I think they anticipated this idea. And then that paragraph after, they say, well, there's no pending claim. They say a less theoretical reason for the immediate appointment of someone is so not to delay the claims from being examined, so it's not this sifting process, a swift investigation. But
When she was officially appointed as the administrator?
by the time she was appointed, the statute had not run.
Well, within the time period, and is her failure to update that fatal?
It's not. And the reason is in order to, Voss clearly applies Rule 1.201, and the second half of Rule 1.201 deals with the concept of relation back. And the district court said, well, the concept of relation back doesn't apply because the word action is in there. But the first half of Rule 1.201 uses the term action as well. So you can't split the rule in half, and clearly the rule must work in concert. And to give a hypothetical to show that this could lead to absurd results is, let's assume that some of the issues here are not being dealt with today, is that Alexandra Anderson was appointed, she files her claim forms, and she files an individual claim. So these issues are not before us. And then, after the statute of limitations runs, she tragically passes away as well. If this logic is carried out, both of those claims would be extinguished, as a new administrator could not be appointed because they were not the claimant, so that would not relate back. Nor would her loss of consortium claim survive, as an administrator would have to be appointed or executor to her estate, and then that could also not relate back, because that second half of Rule 1.201 would not apply. In our mind, that if you're going to apply Rule 1.201, it has to be all or nothing. You can't.
Basis, though, in Voss for rejecting this claim. I mean, they talk some about the relation back and how it couldn't work in that case, but this less theoretical reason is also given by Justice Turnus, and she says, requiring the board to delay consideration of a claim while waiting for the claimant to have legal authority to pursue it would defeat the statutory goal of prompt settlement. And just to be frank, your client, their claim was made when they weren't the person who could have settled on behalf of the state. And isn't that exactly what happened there? That the state couldn't have come forward and settled with them, at least for the estate's claims, correct?
And there's no evidence that the state would have settled within 2 weeks of receiving notice. And that would still require the splitting of Rule 1.201 and saying, well, the first half does apply, that the person must be the real party in interest, but there can be no relation back, as in the second half of Rule 1.201. So it would lead to that same problem where if someone were to die or the administrator couldn't continue, then it can't relate back at all. So it would still still end up with, in our mind, an unjust result. And I wanted to tackle real quickly the idea that Essentially, the state was rewarded for not addressing the claim in this case. That idea, the district court said, well, if they might have invested or denied it, then that would be evidence of exhaustion. And in our opinion, that goes against the spirit of the ITCA, which is to facilitate swift settlement of claims, and is to do substantial justice as set forth in Segura. And I suppose I'll continue the rest of my argument after on rebuttal. Thank you, Your Honors.
This correctly, if I mispronounce it, I apologize. Job Mukkada? Thank you.
May it please the court, counsel. My name is Job Mukkada. I'm an assistant attorney general here on behalf of the state. The Iowa Tort Claims Act has been around for nearly 60 years, and in that time, this court has issued several decisions telling us what is required under the act before the state waives its sovereign immunity and allows itself to be sued for tort in district court. And one of those requirements is presentment. As this court said in Voss, a improperly presented claim or not presenting one at all is a failure to exhaust one's administrative remedies, and it deprives the district court of subject matter jurisdiction, and that's what happened here. The estate improperly presented their claim because Mrs. Anderson did not have the legal capacity as the administrator to bring the claim.
Let's just get to the point that, if we could, about the relation back. Do you agree with counsel that the relation back rule solves all the problems here?
Back rules from the Iowa Civil Procedures do not apply in this case. He mentioned the Voss case. I think what the Voss case does, the Voss case, when it's talking about legal capacity, it doesn't say because the Iowa Rules of Civil Procedure requires real party and interest will say that applies to the Tort Claims Act. It analyzed the Tort Claims Act itself and found that because there's these additional obligations for the Attorney General to investigate, to try to compromise and settle these claims when possible, because of those factors, the Voss court determined that the legislature intended that you have to have legal capacity when you file the claim. And, for this relation back, this idea that a subsequent appointment after you filed a defective claim should somehow apply retroactively, they have to point to something. There's nothing in the Iowa Tort Claims Act that allows for it, so they point to the Rules of Civil Procedure. The Rules of Civil Procedure 1.201 explicitly
A rule of relation back for appointment of administrators. Why wouldn't that apply here?
I think if you look at the Tort Claims Act, it should say something in the Tort Claims Act that allows for the relation back. It talks about other statutes and how to
Of common law regarding administrators and their authority. Why wouldn't that law apply with respect to the authority of this administrator? So in Gardner versus Beck, we say a person who acts prior to appointment, his acts are not binding upon the estate, though they can become so later by ratification when deemed to be in the interest of the estate.
Voss, for instance, determine what is the additional kind of requirements under the Tort Claims Act. If it's the same issues that you're going to have, if someone in the future can come forward as the actual administrator, that defeats the statutory goal of trying to do a prompt settlement when possible.
The statute of limitations. I mean, hypothetically, if this administrator on the day of her appointment had submitted a new claim form, there's no problem here. She met the statute of limitations, so shouldn't we assume that once she's appointed and she doesn't withdraw the claim, that she's ratifying her prior act, which under our controlling law says that's perfectly legal? Why doesn't that apply?
There's another hypothetical where they file the claim the day after the injury, day after the death, and then they don't get appointed until 2 years later. The state can be in a situation where anyone with a tenuous claim can file claims. These are the issues that the Voss court talked about.
Well, the person isn't appointed until after the statute of limitations runs. As long as the appointment occurs prior to the statute of limitations, what's the legal injury to the state?
Because the statute of limitation runs for 2 years, so potentially there's a claim pending, then the state has to wait potentially 2 years up until that statute of limitation runs out before they can actually deal with someone, and that does not facilitate the statutory goal of trying to seek a prompt settlement. And this, it's not just Voss. In our more recent cases on the Iowa Tort Claims Act and this exhaustion issue, Segura and McFadden says you have to have legal capacity at the time you make the claim. And I agree.
A lot of things. I wanted to get to McFadden. It seems to me this is kind of like McFadden in a sense. So McFadden, as I recall, the facts were the person had been appointed the administrator but didn't fill out the form saying they were the administrator. So we sort of said, well, we'll go to the reality, and the reality is they were the administrator. All right, so here the person says they were the administrator. The reality is they became the administrator a couple weeks after submitting the claim, but within the statute of limitations. So why don't we go to the reality here?
McFadden makes the key, that is the key distinction in McFadden, is that in McFadden, they were the administrator when they filed the claim, and in Voss, they were not the administrator when they filed the claim. And I don't think it's not a factual inquiry in whether it would have made a difference or not. And the Bloomquist case says the practical effects of these things isn't what we're looking at. Does not having the legal capacity when you file the claim hinder the statutory goal that the legislature has made as part of its waiver to try to resolve these claims, try to investigate it, to try to sift through these claims.
Argument, does that require some evidence of actual prejudice? So if the state's position is somehow being notified 2 or 3 weeks after the fact that an appointment letter had been issued, where's the evidence that hindered their attempts to settle this case or investigate the case?
I think that is the distinction. What I was trying to say is that it's not a factual inquiry. The state does not have to prove that they were hindered. The reason that we have legal capacity as a requirement when you file a claim is because there is a statutory goal to promptly settle these things. It doesn't mean that we have to prove that in 6 months we took all the steps we could to try to do that. And I think the Voss case also talks about, it might be easy to take one case and say, well, in that case, these things could have been resolved quickly, but we have to consider that the state of Iowa receives about 800 tort claims a year. And when you look at that, how they sift through these administratively on that scale, that becomes really a heavy burden on the state. And again, just Warren, I think there was an easy fix here. There is nothing in the statute that allows for this relation back, but there is a fix here, which is that the claimant could file a new claim within the statute of limitations, and we wouldn't be here. To talk about the loss of consortium claim, what Segura, there we're talking about, obviously they would have the legal capacity to file loss of consortium claims. The issue there is, did they properly present the claim? And Segura and Schneider says, what do we need for the contents of a claim? It has to be in writing. It has to generally describe the legal theories that are being asserted against the case, against the state. And that is what allows the state to do investigation. And it has to identify the damages that are being sought. And that's what's missing in this claim. It doesn't describe, if you read their tort claim, it is being presented as the estate is seeking damages for wrongful death, which includes the estate's entitlement to loss of consortium damages. And that's not what the law, that's not what Madison v. Colby says. It's not what the Iowa Rule of Civil Procedure, the source of this loss of consortium is 1.206. And we also have in the statute 613.15a. These loss of consortium claims are individual claims that the parent owns. They're the ones who bring it. They're the ones who have to file a claim. And I also want to say it's not a matter of did they file separate forms or was it in triplicate. It's not. That's not the issue here. It wasn't identified in that form that they filed. And
Old mistake. Then I was quoting earlier from their resistance to the motion to dismiss, they said that Alexandria and Terry Anderson did not and could not properly submit individual claims to the board. Was that just wrong on their part?
Statement is wrong. The reason why it's fatal to their case here is that they didn't describe a legal theory that the state should know, nor do they describe damages or identify the claimants, that the state should know that, hey, we're not just dealing with one party bringing a claim, we're actually dealing with three parties bringing a claim. And the problem with that again defeats the statutory purpose, because the state is not going to be able to meet that claim and potentially settle it because they think they're only going to have to settle with one entity, where in actuality, there's actually two more parties that are going to be seeking damages as well. And I think the plaintiffs know this, because if you look at the petition that they ended up filing it, they identify all of this. They identify Alexandria Anderson as administrator for the estate and individually, and Mr. Anderson individually. They describe their legal theory. They describe the damages that each entity is trying to get. And it says,
requirement that they break down damages in a way that specifies the different claims?
I think they need to, it depends how far you have to break down. I think the individual parents need to have an amount of damages that they are seeking, because if the state is going to be able to settle it, they have to know what each entity is seeking in damages amount. And so, whether that, I know on the claim form there's 3 lines, however that's put forth in the claim, I don't think matters. I don't think it's a matter necessarily of were they on the right line. But, there's the claim form, there's an attachment. However they wanted to describe that, if it was enough to describe that each entity was seeking this damage under this legal theory, that would be sufficient. If they had put the petition that they eventually filed as an attachment, I think that would have been sufficient as well. But that is what's missing in this claim form.
Claim, as you note, there's only 3 lines. And so are you saying that they should have put something on the property line?
I think when the courts have talked about loss of consortium claim, it's considered a property right. So yes, I think that's a possible way to do it. I mean, the way I usually see it in practice is that each person files a separate tort claim. I don't think that's required. I think they could have filed it as they did, and then in their attachment, when they're describing the claim, there's an attachment for basis of the claim, they could have put it there. They could have put it anywhere, I think, on the claim, but it's not there anywhere.
They filed multiple claim sheets, though, didn't they?
I don't think that was necessary. Ultimately, this is a claim against the state. They did file multiple sheets to identify the individual state employees. They could have also done that on the same form. They could have clicked state and then also checked employees.
Form say that, if I'm reading it right, a separate claim must be filed by each claimant?
Yes, but I think, first of all, I think in light of cases like Segura, whether if they had filed all of this on the same claim form, I don't think we would have had a problem with that. And the Segura holding is that failure to abide by the administrative rules alone will not deprive the court of subject matter jurisdiction. But that's not the issue we're having here. It's not a failure to file, technically according to the administrative rules. It's a failure to abide by the substance of the act itself. And that's a subject matter jurisdiction, that's a sovereign immunity issue. And so that, I think, is construed more strictly than failure to abide by the administrative rules.
Practical problems for the state in responding to tort claims. If we held it was good enough, if a parent jumped the gun and submitted a tort claim before they were appointed administrator, yet were in fact appointed administrator of the estate well within the period of limitations.
I think such a ruling, if you adopt the plaintiff's rule, it's not necessarily confined to just administrators. It's anyone could file a claim on behalf of anyone else, as long as at some point in the future, someone who has the actual legal capacity comes forward. And I think Voss talks about what are the issues. It potentially makes the claim liable to multiple suits. It may be the state settles with someone, and then all of a sudden someone with superior or the actual legal capacity comes forward. I think in this case, you could have had a case where The state thought they were going to, they end up settling this claim. And the state thought, well, that's the end of it. But then all of a sudden they say, well, actually, we had these 2 loss of consortium claims. You didn't settle that. And then we're in a lawsuit for that. And
You're saying in theory, but your office is a good office. I really don't, this is not some mysterious kind of bizarre claim. This is kind of a bread and butter claim. I don't think anyone has any real confusion about what the claim is about, who the relevant parties are. I understand theoretically in the case law you have to argue this, but just as a practical matter, I mean, when somebody's presented with this, it seems to me the chance for risk of confusion and misidentification of the parties and inadvertently settling with the wrong people is extremely low, very, very low in the real world. And I don't know why we should let that kind of hypothetical risk of something that's really never going to happen in a case like this resolve the claim.
Chief Justice, I'm out of time. May I answer? I mean, I think there are the state. What's required on the statute is the state should not just be provided. Yeah.
This is not a complicated case with a difficult legal theory, and maybe there's parties that we don't know about. It's a pretty standard claim here, right?
Could be a standard claim. We see claims like this all the time, but they are properly presented and filed. There's all sorts of situations where there's a wrongful death claim, and for various reasons, people who have a loss of consortium right don't bring loss of consortium claims. So I think there is a real factor there to consider. Thank you. With that, we ask that you affirm this court. Thank you.
Thank you.
All right, I'll try to get through it quickly here, Your Honors. I wanted to address one point he made, is that he said we should have put the damages on the property claim line on this form. And they actually give us some regulations for describing property damage claims. In 543-1.4 sub 25A, subsection 4, they say in connection with property damage or loss. Subsection A, they tell us to describe if it's a motor vehicle. Then in subsection B, they say if it's other property, describe the nature and description of such property, the method by which the property was acquired, the depreciated value of date of damage or loss. Now, one of 2 things is happening here. Either because loss consortium claims don't depreciate, farm equipment does. So they're either confused about their own claim forms and what they mean here, or they're just interpreting the rules in order to defeat legitimate claims. That is clearly not the type of property damage that was claimed here. In their brief, they say, well, that would have given us notice if there was a loss consortium claim. So I think that's a problem in itself. And I think this idea of the state's duty and this burden, the statute says that they shall investigate the claim. And there is no evidence in this case that this claim did anything other.
You know, we have this concept of sort of directory language and mandatory language. You know, when the government is, when it says the government shall do something and they don't do it, frankly, sometimes there's no consequence. If we view the statute the way I think probably both the state and attorneys that sue the state view it, what it really is intended to provide is an opportunity for the state to investigate and settle the claim if it wants to, with the backstop being the 6 months, so that if they haven't done anything or haven't done anything to your satisfaction, you can go to court. And in that sense, it functioned as it should, didn't it?
In my opinion, it didn't, because the state is now claiming some prejudice based on the idea that, well, if this would have been done, you know, we would have had enough theoretically to investigate the claim. But in this case, there's no evidence that that happened other than it sat in a desk and collected dust for 6 months. And they talked about the limited resources of the state, and I have respect for opposing counsel. I think there is a good office there, and I completely understand being overburdened. But if they needed an extension of 6 months, just send us a letter. We'd be happy to work with them there.
About paying off the wrong party, isn't that easily resolved by let us see your letters of appointment, prove up that you're the administrator. If you had gotten such an inquiry, what would have happened?
In Segura, where this idea that they could just contact us, and had we received some sort of clarification, a 5-minute letter, we would have responded, we would have said, yeah, we're happy to clarify that for you. This is what's going on. These are letters of appointment. And I think 5-10 minutes of work would have saved everything, all the motion practice, the current appeal. It was a problem that could have been resolved pretty easily rather than waiting until litigation goes in. I'm sorry, Your Honor.
You wouldn't have had any obligation to comply, isn't that true? Under, what is it, the Schneider case, that folks don't really have an obligation to honor requests for, their voluntary requests for information, right?
Case is slightly different because I think they requested information and then I think the state denied it after the fact. So in my mind, this process of exhaustion is if the state is actively seeking information and then no information is being provided, then I think that administrative process can't seem to be it must be ongoing. So if there's no response from the other side, I think the state would have an argument that says, well, listen, we're waiting on a response for information. So I think it's a little bit different than Schneider, where the claim was actually denied after the state requested information and before a response was received. And I'm almost out of time. Were there any more questions or try to fit something else in? And I think that comes back to the practical problems. There were no practical problems here. Truly, this is a case of form over substance, and our legal system strives to resolve disputes on the merits rather than these technical rules that are serving to defeat a claim. This is an important claim to my clients. It's an important claim to the state, too. And I think this is one that should be resolved on the merits, so we would ask that you reverse the district court's finding. Thank you, Your Honors.
The case of the State of Anderson versus State of Iowa is hereby submitted, and the court is adjourned for the afternoon.